Welcome to this webinar. Lawyers Defending American Democracy is proud to sponsor this panel discussion featuring three of the nation's premier First Amendment scholars to talk to you about the unfortunately terribly timely topic of free speech under siege, echoes of McCarthyism. Before giving you a brief biographical sketch of each speaker, I'll tell you a little about Lawyers Defending American Democracy and about myself, Gary Simson. Lawyers Defending American Democracy is dedicated to preserving, protecting, and strengthening democracy in the United States. It's a nonpartisan organization, and one of its guiding principles is that democracy is a nonpartisan issue, one that all Americans should care about deeply and be eager to unite behind. It was founded during President Trump's first term in response to the very serious threats that the first Trump administration posed to our democracy. From the start, its board of directors has been intimately involved in the organization's work in a way that few organizations' boards ever are. Lawyers Defending American Democracy continues today with an expanded board and with dozens of volunteer attorneys as the threats to democracy have multiplied since the start of President Trump's second term in January 2025. It does its work of protecting democracy and the rule of law in many different ways, ranging from amicus briefs to ethics complaints against lawyers for professional ethics violations, to advocacy through writing, and much more. I'm proud and grateful to be a member of its board of directors. Like today's panelists, I'm a longtime constitutional law professor. I've taught at 4 law schools, including about 25 years at Cornell, and roughly half that number at Mercer Law School, my current school, where I came to serve as dean, and now I'm happily back to full-time teaching and writing. To say that the 3 members of today's panel are accomplished would be the understatement of the year. They're all tremendously prolific and influential writers and speakers. For the sake of time, and because I suspect most of you are already very familiar with them, I'll only highlight a few things about each of them. I should emphasize, though, what an honor it is for Lawyers Defending American Democracy to have all of them together here. First, Erwin Chemerinsky has been the Dean of the University of California at Berkeley School of Law since 2017, where he's also the Jesse Chopra Distinguished Professor of Law. For the decade before moving to Berkeley, he was the Dean of the University of California at Irvine School of Law, and before his 2 deanships, he was on the Duke and University of Southern California law faculties. He's the author of many books, including Worse Than Nothing, The Dangerous Fallacy of Originalism in 2022, and Presumed Guilty, How the Supreme Court Empowered the Police and Subverted Civil Rights in 2021. He's also authored dozens of law review articles. He writes regular columns for the ABA Journal and other publications, and he often argues appellate cases, including in the Supreme Court. He received his undergraduate degree from Northwestern and his JD from Harvard. Next, Kermit Roosevelt III is the David Berger Professor for the Administration of Justice at the University of Pennsylvania Law School. He works in various fields, especially constitutional law and conflict of laws, and he's published scholarly books and numerous law review articles in both of those fields. He often serves as a media expert and keynote speaker, and he's the author of 2 novels, In the Shadow of the Law in 2005 and Allegiance in 2015. In 2014, he was selected by the American Law Institute as the reporter for the 3rd Restatement of Conflict of Laws. He received his undergraduate degree from Harvard, his law degree from Yale, and not long after, he clerked for Justice Souter on the Supreme Court. Finally, Nadine Strossen is the John Marshall Harlan Professor of Law Emerita at New York Law School. She served as president of the American Civil Liberties Union from 1991 to 2008. She's a frequent speaker and media commentator on constitutional law and civil liberties, and has testified before Congress on various occasions. Her many honorary degrees and awards include the Margaret Brent Women Lawyers of Achievement Award in 2017 and the Judy Blume Lifetime Achievement Award for Free Speech in 2023. Her books include Hate, Why We Should Resist It with Free Speech, Not Censorship in 2018, and Free Speech, What Everyone Needs to Know in 2023. And she's published countless articles in scholarly and general interest publications. She graduated from both college and law school at Harvard. Before we get into the many ways in which the Trump administration has shown enormous disrespect for basic free speech principles, I'd like to set the stage for that discussion by reading aloud two things. The first is an excerpt from an opinion written almost 100 years ago by a Supreme Court Justice, Louis Brandeis, in the case of Whitney against California. If anyone has ever written a more powerful and persuasive statement of what makes free speech so important in a democracy and why authoritarian regimes always regard free speech as their enemy, I'm unaware of it. Here's what Justice Brandeis wrote. Those who won our independence believed that the final end of the state was to make men free to develop their faculties, and that in its government, the deliberative forces should prevail over the arbitrary. They valued liberty both as an end and as a means. They believed liberty to be the secret of happiness and courage to be the secret of liberty. They believed that freedom to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth. That without free speech and assembly, discussion would be futile. That with them, discussion affords ordinarily adequate protection against the dissemination of noxious doctrine. That the greatest menace to freedom is an inert people, that public discussion is a political duty, and that this should be a fundamental principle of the American government. They recognized the risks to which all human institutions are subject, but they knew that order cannot be secured merely through fear of punishment for its infraction, that it is hazardous to discourage thought, hope, and imagination, that fear breeds repression, that repression breeds hate, that hate menaces stable government, that the path of safety lies in the opportunity to discuss freely supposed grievances and proposed remedies, and the fitting remedy for evil counsels is good ones. Believing in the power of reason as applied through public discussion, they eschewed silence coerced by law, the argument of force in its worst form. Recognizing the occasional tyrannies of governing majorities, they amended the Constitution so that free speech and assembly should be guaranteed. The second thing I'm going to read quickly takes us from the heights of Brandeis's words to the grave challenges that free speech and democracy face today. 100 days into the second Trump administration, seven national organizations well known for their defense of First Amendment freedoms issued an open letter to leaders of American institutions. In that open letter, they described a, quote, breathtaking array of actions, quote, that President Trump and federal agencies under his control had taken by that point in disregard of First Amendment rights. Among the actions listed in that letter are, and I quote, imposing unconstitutional conditions on a wide range of federal grantees and contractors, sanctioning lawyers for their representation of people whom the president views as political enemies, arresting and threatening to deport international students solely for their participation in lawful political protest, purging crucial databases from government websites, imposing new and indefensible restraints on public employees' right to speak on matters of public concern, invoking civil rights laws to justify extensive and unwarranted intrusions into universities' autonomy and academic freedom, using federal funds as a cudgel to censor curriculum and promote the Trump administration's viewpoints in schools, threatening to revoke the licenses of television and radio networks and stations whose reporting the Trump administration disfavors. That's only a partial list of the actions cited in the letter as ones that the Trump administration took in its first 100 days in defiance of the First Amendment. In the months since, the administration has found many new ways of showing its disrespect for people's free speech rights. Because Lawyers Defending American Democracy has a special focus on lawyers and lawyers' role in helping ensure a democratic society, let's begin by talking about the administration's actions that have taken aim at lawyers and law firms' freedom of speech. Nadine, could you get us started?
Absolutely. But before doing so, Gary, I would like to thank you and Lawyers Defending American Democracy for your truly important work. I especially admire and defend the fact that it is nonpartisan. That is so important. And as a symbol of that importance, I'm wearing the nonpartisan color purple. I'm also delighted to share the podium with Erwin and Kermit. You know, Gary, you read a partial list of the huge infractions against free speech. Reporters are constantly asking me out of this long litany, which is the worst? And if I am forced to choose, I always choose the assault on the legal profession for the following reason: that no law, including the First Amendment, is self-enforcing or self-executing. In fact, the First Amendment was only a dead letter for most of its history. It wasn't until the 20th century, when organizations such as the ACLU and the NAACP were founded expressly to provide lawyers who would educate people as to what their rights were and then empower people to assert those rights through the legal system, that the Supreme Court was able to finally begin to enforce the First Amendment and put teeth into it. But even with organizations such as the ACLU and Lawyers Defending American Democracy and many others, we are still David to the government's Goliath. Let me give you one example from the Trump 1 administration. And as you said, things have gotten worse since then in terms of a ramped up assault on First Amendment freedoms. But people were so upset about Trump's assaults on civil liberties at the beginning of his first administration that the ACLU raised record amounts of money and was able to double the legal staff. And yet, Anthony Romero, the executive director of the ACLU, said, okay, so our staff has doubled from 100 to 200. That's great. But the Department of Justice alone has 10,000 lawyers. And there are many, many other government agencies that are engaged in abusing civil liberties. In the Trump 2 administration, things have gotten worse with the direct assault on law firms. And even though some law firms have stood up against those assaults, and every single firm that has challenged the administration's efforts to suppress their representation of plaintiffs that are challenging the Trump administration policies, every single court that has ruled on those cases has upheld the First Amendment claims. But that is not enough. There is still pervasive intimidation. I just saw an article that was in the Washington Post last week, and the headline is, "Nation's biggest law firms back off from challenging Trump policies. Smaller law firms are being pressed to their limits as they try to pick up the legal slack." And you have, even some of the most wealthy and most powerful and most prestigious law firms in the country, starting with Paul Weiss, succumbing to the administration's pressure. It's no surprise that many others that lack those resources and that stature are also succumbing. I have to mention that the settlements that the Trump administration has extorted from the law firms that haven't stood up to its pressures reportedly amount to $1 billion of free legal services that these firms are contributing to Trump administration initiatives. That means subtracting the same amount of resources that would have been dedicated to challenging Trump administration policies. Many public interest organizations, including the ACLU, including the American Bar Association, that have long depended on amplifying the efforts of their relatively small paid staff members with volunteer lawyers are finding that firms that used to rise to the occasion are no longer doing so. They are simply intimidated. So again, what this shows is that the First Amendment is an absolutely necessary protection for free speech, but it is not sufficient. It requires lawyers who are courageous to stand up. And I love that, I love that whole Brandeis statement that you read, Gary, but the essence is that the secret of happiness is liberty, and the secret of liberty is courage. So I really salute you and other leaders of Lawyers Defending American Democracy for having the courage and dedicating your time and talents to actually making the First Amendment into a reality. Thank you so much.
Erwin or Kermit, anything you want to add?
I think the only thing that I would add, and I agree with everything Nadine said, is I encourage people to read the executive orders that targeted particular law firms, because they're explicit that what the law firms are being punished for is their advocacy. The first law firm to be targeted directly for an executive order like this in a major way was Perkins Coie. And the sanctions that were to be imposed on it would have literally put it out of business. It would have said that none of its lawyers could go into a federal building, including a federal courthouse. It would have said the federal government won't contract with any client represented by Perkins Coie. And you then have to say, well, what did it do to deserve the punishment? The executive order said it represented Hillary Clinton in 2016. Or another example of a firm that was targeted was Sussman Godfrey. And it was the same sanctions being imposed against Perkins Coie. What did it do? Well, it successfully sued Fox News in a case on behalf of Dominion Voting that settled for about $750 million. The First Amendment protects lawyers and their lawful, zealous advocacy. Lawyers should never be punished for the clients that they represent. And that's exactly what the Trump administration was doing.
I agree with everything that's been said. And I would say maybe just one more thing, which is that the way that I think about a lot of this is it's useful to try to distinguish between sort of pure vengeance. The administration is going after someone just because they want to punish them, like Jim Comey or Letitia James, and attempts to break the system or take away the guardrails. And usually there's a mix of those things going on. But when the administration goes after law firms, you can go back to the Shakespeare quote where the revolutionaries are plotting about taking over England, and they say, the first thing we do, let's kill all the lawyers. Judge Beryl Howell quoted that in one of her decisions about these executive orders. Lawyers are essential to the constitutional system of checks and balances that we have set up, because as Nadine said, the First Amendment, the Constitution, it's not self-executing. And we talk a lot about separation of powers and the role of judges and courts, but you need the lawyers in there making those arguments to the judges in the courts. And so a large part of this is not just vengeance against lawyers who've done things that angered Trump. It is an attempt to cripple resistance.
Thank you. As law professors, the members of this panel have gotten to see up close the administration's attack on free speech in universities. Erwin, as the law dean of one of the nation's great research universities, you've gotten an especially good look at the breadth and scale of this attack. What thoughts would you like to share?
It is an unprecedented attack on universities. It's very much from the playbook that we see from authoritarians or would-be authoritarians in other countries. Let me just give 3 examples of this. One is revoking student visas on account of their speech. We saw this initially with regard to a student from Columbia University, Muhammad Khalil, and he was having his visa revoked. He was taken into custody just because of advocacy. But we've seen this for a number of other individuals. The United States Supreme Court made clear in 1945 in Bridges versus Wixon that the First Amendment protects the speech of all in this country, citizen and non-citizen alike, and to revoke visas on the basis of expression is unconstitutional. It also has a tremendous chilling effect on the speech of students, and I see that in my law school and on my campus. Second, there's been the cutoff of funds from universities and from researchers in ways that violate the First Amendment. We can start talking about the $400 million cut off from Columbia, or the $2 billion cut off from Harvard. And the ostensible reason was the speech that they allowed on their campuses, overwhelmingly and entirely speech protected by the First Amendment. President Trump says this is because they tolerated anti-Semitism. But if that was what it's about, Title VI of the 1964 Civil Rights Act prescribes the procedures to be followed. It has to be that the university gets notice, that before there's any cutoff of funds, there's a hearing and finding of facts. There can't be a cutoff of funds because there's 30 days notice about the House and the Senate. Funds can be cut off only for a program that's found to violate federal law. The Trump administration followed none of that. But there's also the cutoff of funds to researchers themselves. As of the beginning of June, $350 million has been cut off to University of California faculty and researchers, according to the Department of Government Efficiency website. Actually, that's inaccurate. Much more than that was cut off. I'm one of the co-counsel who filed a lawsuit for this, and we won a preliminary injunction. The Ninth Circuit refused to stay. It's a case called the Kerr versus Trump. And the district court in the Ninth Circuit found that the cutoff of funds violated the First Amendment. What the Trump administration did was do keyword searches and cut off any grants that use words like diversity. So one of the named plaintiffs in our lawsuit was doing work on plant diversity. Another named plaintiff was doing work on diversity of the microbes in the human stomach and had grants cut off. But because of the perceived ideology of the research, the grants were terminated. Federal judge in Boston, in a suit brought by Harvard, found that the cutoff of the money to Harvard violated the First Amendment because of the perceived viewpoint expressed. If anything is at the core of the First Amendment, it's that the government can't punish speech or deny benefit speech based on the viewpoint expressed. And third, I want to say just a word about President Trump's so-called compact with education. On October 1st, a letter was sent to 9 universities saying that they would get a preference in federal funding if they'd agree to certain terms. And it says at the end that any university that doesn't agree to this can forego federal money. The terms so clearly violate the First Amendment. One of them said that a university has to punish anyone who, quote, belittles conservative ideas. On its face, that's viewpoint discrimination. Beyond that, there's a First Amendment right to belittle any idea, conservative or liberal. It says that universities must ensure that all administrators and faculty in their official capacity cannot take positions on political or social issues. Well, when a professor goes into a classroom, it's in an official capacity. It would seem to take views on disputed issues that would be impermissible. It requires that every department hire faculty for the sake of viewpoint diversity. We can't hire faculty because they're liberal or conservative. That would violate the First Amendment. Yet all of this is in the compact with education. I hope every university rejects it. It is an unprecedented assault on academic freedom in the United States.
I would like to add something to Erwin's powerful remarks, and that is that, as Erwin well knows, I've been very involved, as has he, with organizations that have been critiquing many universities, including Harvard and Columbia and other targets of Trump for what we consider to be insufficient protection of academic freedom and insufficient promotion of viewpoint diversity and insufficient countering of anti-Semitic violence and discrimination and unprotected anti-Semitic speech, such as intimidation and threats. Nonetheless, to cite a cliche, 2 wrongs do not make a right. And I personally, and the organizations I've been working with, including FIRE and the Foundation for Individual Rights and Expression, Heterodox Academy, Academic Freedom Alliance, for all of the critiques we've had of universities, we are much louder and more concerned about what the Trump administration is doing. You cannot destroy academic freedom for the purported sake of protecting it. You cannot mandate viewpoint diversity that is antithetical to the concept of viewpoint diversity and institutional autonomy. And in the spirit of bipartisanship that this wonderful organization, LDAD, represents, I have to say that it has been a traditional conservative and Republican position to oppose intrusive federal government involvement in universities, even state universities, let alone private universities. When the Department of Education was first created, it was the Republicans who opposed it because they said this is not a matter for the federal government. So I just urge, conservatives out there, please be true to those principles, which really are important for preserving the autonomy of these essential pillars of civil society that perform so many essential functions in a democracy, including serving as a check and balance on overweening government power.
I completely agree with what both Nadine and Erwin said. And just to sort of amplify that, I think it's absolutely true that universities should take a hard look at the campus environment and see if there are viewpoints that people are afraid to express and see if they're turning into ideological echo chambers. But the whole point of the First Amendment, really one of the most fundamental First Amendment ideas, is we don't trust the government to decide what's an appropriate speech environment and then mandate that. And for good reason, I think, because if you look at this compact and the proposals that the Trump administration has made, they talk about diversity and they talk about neutrality, but it's actually pretty heavily skewed. It's conservative ideas that you can't criticize, it's conservative views that have to have this presence. So, they're talking the language of neutrality and equality, but they're actually imposing viewpoint discrimination.
So it would be good to hear more about some of the other ways listed in that open letter, ways in which the administration has put free speech under siege. And Kermit, I'm wondering anything else you would want to highlight for the audience?
Yeah, I think, there are a lot to pick from on that list, but I'd go with one that's sort of really obvious and shocking, and then one that's maybe less obvious. So the shocking one is just grabbing international students off the street and trying to deport them because of their speech. With Rumeysa Ozturk, it seems to come down to an op-ed that she wrote. And you can just see the video. People thought it was a kidnapping. It looks like a kidnapping. And it seems pretty clear, again, that one, sure, they're going after her because they don't like her, but also they are trying very deliberately to manufacture a chilling effect because they're doing this in the most visible, terrifying way possible. They're manipulating the system to make it as unpleasant as possible for the people that they're grabbing. They're trying to evade judicial review by moving them from one place to another. And the lower courts have been good here. The lawyers have been good. But it sort of remains to be seen what the Supreme Court is going to do and where we're going to end up with this. Then the second one, the less obvious one, which I think is interesting because it raises some interesting questions about the First Amendment proper versus free speech values. So we don't usually think that the First Amendment is implicated by government speech, right? The government can say what it wants, and of course, if it wants not to speak, the government can also decline to speak. But questions about government speech do definitely implicate what you could call free speech values. And one of the most troubling things that the Trump administration has been doing, I think, is the way that they're silencing parts of the government. So they're pulling a lot of content from museums, they're taking information down from government websites. And what is the effect of that? Well, the government is restricting our access to information that we, the people, need to evaluate its performance, to understand our history, to get a full picture of who we are as a nation and who we want to be and what we don't want to repeat from the past. So they're pulling information on public health and climate change. They're pulling anything having to do with diversity from these museums, so like history, science. They're taking a lot of very important information away from us. And that might not be a First Amendment concern. I mean, maybe if they're doing it in a viewpoint biased way, it is, but it definitely implicates free speech and self-governance.
So in the past couple of months, there have been two actions by the administration that to me seem to fall into a different and in some ways even more dangerous category than the actions listed in that open letter. First, I'm referring to the comments by the president and many in his administration calling for private retribution, firing people from jobs and more against people who in any way criticize Charlie Kirk, the highly influential Trump supporter who was shockingly murdered in the course of exercising his free speech rights. The second thing I'm referring to is the president's posting on social media of an AI-generated video showing him flying a jet over participants in a No Kings rally and dumping excrement on them. So Nadine, I'm wondering if you find either or both of those as chilling as I do.
Well, the important question, Gary, is not you and me, with all due respect to us, but the general, predictable, and palpable, demonstrable chilling impact on members of the public more broadly. And what I find shocking about these incidents is that Donald Trump actually campaigned as a pro-free speech, anti-censorship president. That was a very strong message. And on day one of term two, one of his very first executive orders, it may have even been the very first one, was saying, you know, I'm going to end censorship by the government and promote free speech. He and other conservatives were so critical of progressive cancel culture. They were so critical of attempts by the left to suppress what they saw as hate speech against racial and gender minorities and so forth. And on a dime, you know, no sooner is the so-called pro-free speech executive order issued than Trump is already engaging in a whole litany of the censorship measures that we've talked about, but also engaging with ramped up intensity after the horrible assassination of Charlie Kirk in right-wing cancel culture. And it's more than cancel culture, because cancel culture can consist simply of members of a society exercising their own free speech rights in ways that we would find chilling to free speech. So we would not want to punish them, but we would want to discourage them from shaming and shunning and ostracizing. But this goes beyond that when you have top government officials, including Trump and Vance and the Attorney General and others, you know, goading on individuals to ferret out comments that are deemed insufficiently respectful of Charlie Kirk and then seeking to punish them. So again, I want to come back to the important LDAD theme of nonpartisanship. Please, please, to all of the conservatives out there, if you truly deplore cancel culture from the left, and I was so grateful when you did that, please equally deplore cancel culture from the right. By the way, I want to say this to my own tribe as well. I'm on the liberal side of the political spectrum, and I have seen, thankfully, many liberals and progressives who were not so outspoken against violations of free speech when they were coming from either the Biden administration or other Democratic officials, or when they were coming from progressive segments of the campus community. Now that you understand how potent these tools are in suppressing speech that you agree with, please understand that if you want to continue to protect speech that you like, you've got to defend freedom for speech that you loathe moving forward.
Erwin or Kermit, either of you want to add to that at all? You can't improve on it, but if you want to add. Okay. The title of the webinar is Free Speech Under Siege, Echoes of McCarthyism. And Kermit, I'm wondering if you could talk to the audience a little bit, explain what was the McCarthy era, and does the comparison to that era ring true to you?
Yeah, so the McCarthy era gets its name from Senator Joseph McCarthy, who leads these anti-communist witch hunts, basically. So there's a sort of frenzy about the threat posed by communism and concern and fear that there are communists everywhere trying to destroy the United States, trying to overthrow our system of government. And like any kind of moment of mass hysteria, you get people who are accused with very little evidence, and they get blacklisted, they lose their jobs, their lives are ruined. And Eventually looking back on it, we're like, wow, that was a mistake. That was an overreaction. A lot of innocent people suffered. So on the one hand, I think there are definitely some similarities, because one of the things that we're seeing the administration doing is making these accusations of anti-Semitism and anti-Americanism and inciting violence and attempting to destroy our country, where there really just isn't that much support for them. If you look at what the administration actually comes up with whenever it's forced to produce evidence, often it's really underwhelming. I think there are some differences, though, in that, like, I feel that Joseph McCarthy and the Red Baiters, they really hated communism. They were sort of mistaken about who was a communist. They were maybe mistaken about what communism was, but they were pretty honest and sincere in terms of like what they wanted to get rid of. And the administration now, I feel, is much more pretextual. So their loudly touted concern about anti-Semitism, I don't think that they really care that much about anti-Semitism. I think they're using that as a pretext to try to assert power over universities. Now, I should also say, like, I think this is a difference in degree rather than kind, because it's very common for people to try to stoke fear and then use that fear to achieve other objectives. That's a very basic political move. You see it over and over again. And you did actually sort of see that with anti-communism. So, when conservatives were opposing child labor laws, they called them communist. When they were opposing the New Deal, when they were opposing even women's right to vote, they were like, that's communism. So you do see this kind of opportunistic use of scary labels. But I feel like the administration is a little bit more pretextual this time around. And the way that they're attacking attempts to promote equality or attempts to reduce discrimination in the name of equality and anti-discrimination, that's another move that I don't think you saw so much in the McCarthy era. So it's a little different. There are definitely strong similarities. And I think, ultimately it's a difference in degree rather than kind.
If I could weigh in on a hopeful note here, I just read something that was actually published in August of this year, which I commend to everybody, by David Cole, who was the legal director of the ACLU for a few years. He's now returned to his position as a professor at Georgetown Law School. And this was in The Nation magazine, and he actually made a very encouraging case that we have much more resistance to the tactics that are being deployed now than existed during the McCarthy period, which he pointed out went on for 10 years, was pervasive throughout society, throughout all levels of government, and through the private sector as well, and that there wasn't pushback in the courts. Now, as we've already discussed, the courts are consistently, at least at the lower court level, ruling against the Trump administration. He also pointed out that we have many local governments, state and municipal governments, that are resisting Trump administration initiatives and bringing lawsuits against it, also successfully. And those tactics were also not used during the McCarthy administration. So again, thanks to the lawyers who are involved in those efforts, we have a somewhat more reason for hope based on this analysis.
I think what Nadine says is important. I thought David Cole's piece was terrific. And it's difficult to draw parallels because there's always some similarities and some differences. A similarity is that people in the McCarthy era were fired just because of their speech or because of their perceived ideological leanings. There are a number of instances after the tragic assassination of Charlie Kirk of people being fired just for what they said, including on social media. A professor at the University of Arkansas Law School was fired on account of her speech. Last winter, a professor at Louisiana State University was suspended just on account of his speech. And we're talking here about very mild speech, unquestionably protected by the First Amendment. Certainly, it's true that it's not at the extent, the widespread nature we saw in the McCarthy era, but still we should be troubled by it. And also, the McCarthy era wasn't led by the President of the United States. Neither Harry Truman nor Dwight Eisenhower, the ones leading the charge. Here, what we've never seen in history is a president of the United States targeting speech in this way. I'm hopeful, as Nadine and David Cole are, that the courts will stand up to it, but I don't think we know at this moment in time.
Well, that leads us very much into the next question. One of the hallmarks of this Supreme Court in the 20 years it's been headed by Chief Justice Roberts has been its expansive protection for free speech. Various scholars have argued that it's been even more protective of free speech than the Warren Court. You might think that would provide some reassurance that when challenges in court to the administration's actions defying the First Amendment make their way up to the Supreme Court, the court will provide an important check on the administration. On the other hand, even before President Trump returned to office, the Supreme Court has made clear that it's a strong supporter of executive power. And since President Trump has been back in office, the court has ruled with stunning regularity in favor of the administration in its emergency docket cases, its quote, shadow docket of petitions seeking temporary relief as cases make their way up to the court for full hearing and final decision. So, Erwin, how much of a check do you expect the Supreme Court to provide to the administration's defiance of the First Amendment?
The only answer we can give at this moment in time is we just don't know. Now, I also think that the praise for the Roberts Court being so pro-free speech is exaggerated. I can point to cases like Garcetti versus Sabalas in 2006 that held that there's no First Amendment protection for speech of government employees on the job and the scope of their duties, or Humanitarian Law Project versus Holder, which was argued by David Cole, where the Supreme Court said the government can punish speech activities that support organizations that are labeled as terrorists, or last year where the Supreme Court unanimously upheld the law prohibiting TikTok in TikTok versus Garland. But to answer your specific question, there haven't yet been matters involving the First Amendment on the Supreme Court's merit docket or shadow docket that concern Trump administration actions. There have been a lot of other matters concerning the Trump administration before the Supreme Court. And to step back a moment, the district courts across the country have been terrific in issuing temporary restraining order and preliminary injunctions. It's a myriad of unconstitutional Trump administration actions. And this includes district court judges appointed by both Democratic and Republican presidents. For the most part, the federal courts of appeals have upheld this. But when it's come to the Supreme Court has reversed almost all of them. In one instance, it was in a case they took and put on the merits docket, Trump versus Casa, that said federal courts can't issue nationwide injunctions. But by count, there have been 39 matters on the Supreme Court's emergency docket since January 20th involving the Trump administration. And the Supreme Court has ruled in favor of the Trump administration in 36 out of 39. For a while, I was wanting to believe that the Supreme Court was going to defer to the Trump administration on separation of powers issues, but when it came to individual liberties, there the court would draw the line. And then on September 8th, in Nome versus Perdomo, the Supreme Court reversed the lower courts that had said ICE agents can't engage in racial profiling, that they can stop people without reasonable suspicion. And the Supreme Court did that without any opinion or explanation, though Justice Kavanaugh wrote an opinion himself and Justice Sotomayor wrote a blistering dissent. That makes me worry. Is it, when it comes to the First Amendment, going to be the place where the Supreme Court stands up to the Trump administration? Or do we have a majority of the justices who are just Team Trump and are going to rubber stamp whatever the Trump administration does? We don't have the evidence at this point with regard to the First Amendment either way.
So I think we're all agreed that these are dark days for free speech in the United States, but I think we're also agreed that the fight for free speech and democracy in the US, it's far from over. A number of things give me hope that the forces for free speech and democracy will prevail. The larger and larger crowds at the 3 No Kings rallies this year, the courage and resoluteness of the many pro-democracy organizations throughout the US, the exponential growth in the number of attorneys, lawyers defending American democracy has had volunteer to do work since the beginning of 2025. My conversations with many law students who come to me asking, what can they do? Those are just some things. Nadine, what, if anything, makes you hopeful that free speech and democracy will make it through this challenge intact?
I am hopeful, Gary. As an activist, you can generally have to be an optimist. And I have under my email signature one of those quotes that nobody ever has time to read, but from David Cole, who in turn is quoting Cornel West, who's probably quoting somebody else, who says that activism, far from being more than being the consequence, optimism more than being the cause of activism is its consequence. You can, in other words, you cannot be an activist without, as a result, meeting wonderful people, including all of the people on this panel today and the organizations that we work with, the students that you mentioned that come to us that are seeking not just to be participating in protests, important as that is, other people who seek to be not only checkbook activists, important as that is, but really to use whatever their talents and skills are to make a difference. That has been really, really inspiring. In addition to longstanding organizations such as the ACLU being increasing its membership and volunteer lawyers and so forth, we also have a host of new organizations, including Lawyers Defending American Democracy, which is fairly new, specifically on the free speech front. We have the Academic Freedom Alliance and Heterodox Academy and several others. I want to mention again, in the spirit of nonpartisanship and lawyers, I was happy fairly recently to learn about a lawyers organization of conservative Republican lawyers who had served in top positions in former Republican administrations that were distressed by what was happening during the first Trump administration. So they founded an organization called Checks and Balances in 2018. They recently renamed themselves in 2023 as the Society for the Rule of Law. I mean, these values that we're talking about are not liberal or conservative. They're not Democratic or Republican. And, you know, when it comes right down to it, every defense of democracy in this country really has come down to we the people. That has been recognized. Zechariah Chafee said it in the first great free speech treatise that was ever written in this country in 1920. He was a Harvard Law School professor and a founder of the ACLU. He said, in the long run, people in this country will have just as much freedom of speech as they want. If we don't care about it, we're going to elect government officials who don't care about it, and they will appoint judges who don't care about it. But the opposite is also true. And more generally, and I think even more famously, Judge Learned Hand said this so brilliantly in his famous Spirit of Liberty speech in 1944. You know, when liberty lives in the hearts and minds of men and women, it needs no law, no constitution to save it. When it does not live there, no law, no court, no constitution can save it. So I think that the public involvement and the involvement of individuals cannot be overstated in terms of how crucial it is. Everybody has to understand that they really can make a difference.
Along the lines of what Nadine was raising, I want to give the speakers a chance to share with the audience advice you have for people, lawyers as well as non-lawyers, who want to know what they can and should be doing to make a difference in these difficult times. Kermit, would you like to go first?
Yeah, so this really is just building on what Nadine said, because I think ultimately it does come down to what the American people want. And I should say I'm an optimist about that, right? I think that the American people want liberty, that we don't want to be an authoritarian nation. But what do you do to make that happen? Well, first vote, right? Obviously that's the most direct thing you can do. Participate in democracy, vote for people who are going to protect our rights. If you haven't voted, like, get out there and vote. Second, probably the most effective thing is to support litigation. So lawyers are very important. The lower court judges have done a great job, I think. And the greatest impact that you can have if you want to spend money is probably supporting an organization that's litigating. Then the third thing I would say, protest, like get out there on the streets. It's very important when we have these rallies to defend democracy or affirm our desire not to be ruled by a king, that there are a lot of people out there. What is the government trying to do when they try to chill speech and stop people from talking? Part of it is they don't want people to hear certain things. But a lot of it is also they don't want people to know how many other people agree with them, how many other people think what's going on now is bad. So making disagreement public, that's very important. And then last, sort of most subtle maybe, but maybe most fundamental is just talk to each other. It's very important for us to be able to talk to each other as fellow Americans and share our views and share our values and share our hopes for the future. Just to go back to the quote that you read at the beginning, public discussion is a political duty, right? That's what Brandeis said.
I certainly agree with everything that was just said. I think where I might be a little bit different than Nadine and Kermit is at this moment, I'm not an optimist and I'm not a pessimist. I'm just scared. I'm more afraid for the future of American democracy than I've ever been or could imagine being. There was a wonderful editorial in the New York Times this week that talks about how do we know if we're on the path towards authoritarianism, and goes through 10 different measures and shows on each of them we're taking steps we haven't seen before in this country towards that. And so my answer in terms of what we do is very similar to what the other panelists have said. First, I think it's essential that people be informed. I've heard too many people say, the news is too depressing, I'm not going to read it or listen to it. We can't afford that. And when we're informed, we will have an obligation to help inform others. Second, we have to be involved. And there's many ways of being involved. There's terrific organizations. We've mentioned some of them: ACLU, Common Cause, Protect Democracy, Democracy Forward. They need volunteers in many instances, and they certainly can use financial support. There's the opportunity for many of us as lawyers to be involved in handling pro bono litigation and representing immigrants who are facing deportation and bringing challenges to police departments or ICE actions. As lawyers, we have that opportunity, and I think we then have that responsibility. And third, we have to find ways to speak out. I agree with what Nadine said, that democracy will die in silence, but it won't if people use their voices. And there are infinite ways to speaking out. It could be simply letters to members of Congress and the Senate. They actually do pay attention to the letters. It could be petitions. It could be going to rallies like No Kings rallies. I think there were 7 million people at the one a week ago Saturday, but what if it wasn't 7 million? But what if it was 25 million or 50 million or 75 million? It becomes much harder for Congress, maybe for the executive, and even for the Supreme Court to ignore. So I think this is an unprecedented time, and we have personal responsibility to take action.
Well, I can't improve on what Kermit and Erwin said, but Erwin, let me come back to you on the hope and fear, because I feel both of them. And Kermit alluded quite wisely to how fear mongering is something that is done in service of in aggrandizing government power. It has been one of Trump's tools, as it has been the tool of everybody, Democrat and Republican, who has imposed measures in response to having raised fears, sometimes justified, sometimes not justified, usually exaggerated fears about national security, personal safety, some other threat. And I think we have to let our hope triumph over the fear. I found many quotes to that effect. Of course, it was the whole spirit of Martin Luther King and the civil rights movement. I'll go back to my childhood idol from when he was elected president, JFK. We should not let our fears hold us back from pursuing our hopes. And I think that is not at all to disparage or diminish the realism of the fear, Erwin. And I know this, I'm preaching to the choir. You are not letting your fear deter you from pursuing your hopes.
Well, I need to bring today's session to a close, and I want to thank the three panelists for their extremely thoughtful and illuminating remarks. I certainly learned a lot, and I think they provided a lot of food for thought and inspiration. I also want to thank Lauren Rickling, the Executive Director of Lawyers Defending American Democracy. As every member of the board would tell you, Lauren is at the center of everything Lawyers Defending American Democracy accomplishes, and this webinar is no exception. I also want to thank Lauren's assistant, Hannah Zach, a first-year law student who handled the details and technology for this session so skillfully. I encourage all of you watching this webinar to sign up for the next one sponsored by Lawyers Defending American Democracy. It's on Tuesday, November 20th from 4:30 to 5:30. It's from the social media feed to the courtroom, how judges and jurors remain impartial. And it will feature a distinguished panel of judges and lawyers discussing the impact that the constant barrage of social media and public commentary has on judicial proceedings. If you go to the website, LDAD.org, you'll be able to register and to learn more about the organization. And when you do, I also hope you'll decide to join the growing ranks of volunteers we have. You can volunteer through the website, and your interest and involvement will be very much appreciated. So thank you all for joining us today.